Yes, I would like to thank you and the court personally for accommodating through everything. I mean, you bent over backward to make sure that I was able to be there and through Zoom or whatever. I know that you've done a lot to make that happen. I'm real very appreciative. Um, so thank you to you and the court, and thank you, Robert, for those very kind words. I just want to be a good dad and a good husband.
Go ahead.
I'm sorry, Your Honor. Robert Goldman, P81222, appear on behalf of defendant Jason Michael Eckel, present by way of Zoom this afternoon. Your Honor, we thank the court for its accommodations to appear over Zoom. We do consent to this proceeding being held over Zoom. Mr. Eckel, would you please unmute yourself and state your name for the record? Your Honor, this is the date and time set for a sentencing hearing in this matter. As the court may recall, this matter has been adjourned from the January 28th, 2026 sentencing date as a result of Mr. Eckel having been hospitalized at that time. Your Honor, Mr. Eckel is presently still hospitalized at the University of Michigan Hospital, which is why he does appear by way of Zoom today. For purposes of sentencing, Your Honor, we have received and reviewed the pre-sentence interview and report and recommendation provided by the probation department. We don't have any additions, deletions, or corrections to be made to that at this time and are otherwise prepared to proceed with sentencing.
Is there anything either of you would like to say before I do impose sentence?
Yes, Your Honor. With respect to Mr. Eckel, this matter and these charges, I would say to the court, this has been an instance where it's been truly a pleasure to work with Mr. Eckel. Mr. Eckel and I did not know each other prior to his representation, but over the course of time working with him since the arrest of September 2024, I've had a great opportunity to really see how Mr. Eckel has put into action very much what he's discussed with the evaluator, with Ms. Pilara and the court in terms of the good faith effort to address past issues involving alcohol, primarily with alcohol and operating a motor vehicle. At the time of Mr. Eckel entering his plea and in December of 2025, Mr. Eckel had, in very much good faith, gone forward for screening purposes for sobriety court. And unfortunately, Mr. Eckel was not deemed a good candidate for sobriety court because he was considered to be too low risk at that time. The reason he was too low risk was because when he presented for such screening, he had over a year, upwards of a year and a half of sobriety intact, without relapse, without issue. And he has done very well for himself in terms of addressing his issues, maintaining that abstinence, and really going forward in a much reformed manner. Now, unfortunately, Your Honor, this matter has coincided with a very significant health-related issue Mr. Eckel is undergoing at this time.
A hospitalized defendant appeared over Zoom for sentencing, thanking the judge for accommodating his medical condition. Fighting for sobriety and awaiting a liver transplant, he told the court he just wanted to be a good father and husband. The courtroom grew quiet as the judge prepared to respond.
Mr. Eckel is dealing with a liver issue and is requiring a liver transplant, which we do anticipate to happen within the next 1 to 2 weeks. But Your Honor, both with respect to Mr. Eckel's health conditions as a basis or motivation for his sobriety, the sobriety really comes from Mr. Eckel wanting to be the best version of himself, not for himself solely, but really with respect to his young children. Mr. Eckel and I were recently speaking regarding his oldest child, who just turned 16 and has just received his license. And it's a very proud moment for Mr. Eckel as a father, but it's also been a very important opportunity for Mr. Eckel to take great stock of his life, his experience, and what he needs to do in order to be the best example and really a model for his son as his son grows and maintains this license, to avoid situations or circumstances such as the one that finds us here today before Your Honor. Mr. Eckel, I think in very much good faith, meaningful sense, has taken the experience he has gone through here, has adopted a new perspective, one in which will allow him to go forward in a very productive, healthy sense. He has a very significant health battle ahead of him, but he is prepared for it. He is approaching it with the right mentality and understanding what he needs to do for his health and for his life to be the father, the community member, and the individual that so many have come to recognize and appreciate, and myself included, Your Honor. It has been truly a great opportunity to get to learn from Mr. Eckel as much as we've tried to help him learn through this process. I have utmost confidence that if the court is to adopt the terms of the recommendation, Mr. Eckel will be a model probationer, and to show this court that the actions that have brought him before here are not a true representative of his character, of his nature. And I do believe that the court will ultimately see the responsible, law-abiding individual that Mr. Eckel truly is.
Thank you. Mr. Eckel, is there anything you want to say, sir?
Yes, I would like to thank you and the court personally for accommodating through everything. I mean, you've bent over backward to make sure that I was able to be there, and through Zoom or whatever. I know that you've done a lot to make that happen. I'm very appreciative. So thank you to you and the court, and thank you, Robert, for those very kind words. I just want to be a good dad and a good husband.
Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. So therefore, the sentence of the court, I will place you on probation for a period of 24 months. You are to pay $1,255 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $720 probation oversight fees. When do you think you'd be able to get that paid, sir? I'm not.
That sounds roughly about $2,000 if I added quick enough. Right now, obviously, I'm not working. I will be collecting short-term disability to cover the costs of living, but that's only about 60% of what I usually make.
All right, you can stop there. You can stop there with your calculation. Miss Polera, where is she? She on?
Hi, Your Honor.
All right. Here's what I'm going to do.
The judge imposed 24 months of probation, fines, treatment, and short jail time, but then did something unexpected. He ordered that $100 be deducted from the costs for every month the defendant maintains sobriety, tying financial relief directly to recovery and accountability.
Mr. Eckel, it's a payment plan as arranged by probation. I want $100 deducted from the cost each month that he continues his sobriety.
Okay.
Okay. You got that,
Thank
Mr. Eckel?
Thank you. Thank you.
You're welcome, sir. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Dawn Farm outpatient treatment program, including all recommended aftercare with status reports to probation. You're to provide proof of the victim's impact panel attendance to probation, or you will discontinue the sober lane. Mainly because it's mandatory on this, but I'm going to do it this way because I got to effectuate part of the sentence within a year. 365 days in jail. Credit 1. Defendant to serve an additional 4 days. I'm going to order that the defendant is to report to the Washtenaw County Jail on December 30th, 2026 at 8 a.m. All right. That is health, with his health allowing that to occur. If there is an issue, counsel, you can bring that before the court and I will readjust that report date. All right. The balance then will be suspended.
Thank you, Your Honor.
All right. And Ms. Polera,
Yes, Your Honor.
you can certainly translate what that means to them.
Yes, I will do. I will do that. I will reach out to Mr. Goldman and to Mr. Eckel.
All right. Mr. Echo, do me a favor, my friend. Take
Yes.
care of yourself. You'll make it through this. You've made it through a lot. You'll do it for your kids. And if I can just say so and take a matter of personal privilege, it's been a pleasure being your judge, okay? And watching what you can do, all right? And for me and all my court staff, you will be in our prayers as you kind of move forward on this, sir. All right?
Thank you. Thank you, Your Honor. Thank you. I appreciate that.
Take care.
Okay, thanks.
Thank you, Your Honor.
Thank you, sir. Court calls the case of Arbor Meadows versus Akio Fujima.
Good afternoon, Your Honor. Gabriel Lacey for Arbor Meadows.
Thomas Stringer appearing on behalf of Akio Fujima.
Good morning, or good afternoon, Mr. Stringer. Always a pleasure, sir.
Good to see you again.
I wish I could say that about you, Lacey, but I won't.
Hmm.
No, all right. You know, I don't mean that. All right, where are we on this case?
Your Honor, we're here for a non-payment rent case where specifically the defendant refused to pay the court cost of a prior case. We came here some time ago and entered a conditional dismissal on a termination case. Or consent judgment is one of the two. I believe it was a conditional dismissal.
It was.
And while there was made no mention of the dollar amount of court costs on the record, he was given notice that he had $175 in court costs due. He was given written notice by his landlord, and he refused to pay them. Since that date, the court costs have accrued late fees totaling $425, and additional court costs for having to file this case, $175, leaving a total.
Are these court costs based upon a conditional order dismissal from another case?
Yes.
Okay, go ahead.
So it's leaving a total balance of $600.
Hold it. So the $600 balance that he owes right now is $175 of court costs from a previous case. And then late fees on that.
That is correct. Late fees on that, and then another $175 for having to file this case.
Yes. So why wasn't it taken care of in the other case?
He refused to pay the court costs. It was a termination case, so it wasn't a non-payment case, but he refused to pay the court costs as after the case resolved.
But were the court costs part of the judgment in the previous case?
So when the
Court costs, nobody has to pay court costs until I order it. I mean, that's part of the problem. So in the previous case, because I don't have that in front of me, did I order court costs?
No. I have the video.
Well, Your Honor, according to NCR 2.625 subsection A1, the costs are awarded to the prevailing party unless otherwise prohibited.
Are awarded would be the operative words. I award them. They are not just, and if I didn't award them, and you didn't insist that I award them at the time, they haven't been awarded to you.
I'll file an amendment on the other case. Until then, we'll do what the court orders today.
Well, what's on that other case?
The other case was a conditional dismissal. Gave some terms and conditions he was supposed to comply with within a 7-month period. There was no mention of any costs. So we reached that agreement on the record. And again, then afterwards, counsel prepared a judgment that had those costs added to the judgment. And I wrote back to her saying, well, we never agreed to those, so we never put that on the record. So those aren't owed. And then the park started adding up, saying you owe 175.
Why are we here? I don't get this. Because when was that previous case?
October, November of last year.
It's because the park gave him opportunity to pay the cost.
Pay the costs that weren't awarded by the court, and he didn't do it.
Before ending the hearing, the judge looked at the defendant and spoke personally. Take care of yourself. You'll make it through this. He even added that the court staff would keep him in their prayers, a rare moment of humanity inside a sentencing hearing.
So what do you want me to do with this? Because, I mean, I can grab the other case, deny your request for relief now, and then we can be done. Because I don't see how would I change that if the parties...
Well, the court rule does allow for an amendment because the court rule calls it a clerical error if the costs were not mentioned on the record.
You're gonna tell me it was a clerical error on a landlord-tenant case that costs were...
According to the court rule, there has to be no oral motion for the costs.
What? You can brief it all you want. I mean, if you want to. I got nothing but time. So
Oh, we don't want to spend any more money on it.
I understand. I don't get.
The statutory court costs, Your Honor.
When awarded.
That's not what the,
Read the court rule again.
it doesn't say when awarded, it says they are awarded.
And if not, they haven't been awarded.
If they're not, they said there's no waiver placed on the record and no order denying costs. That's the only.
So you want an order denying it? Keep working. We'll get there. Did he comply with the conditional order dismissal?
Not fully yet.
Well, he's got 7 months. If he violates it, then they can file a petition to reinstate it. No allegations of any violations, and he's compliant. What I don't understand is maybe a petition to clarify could have been filed by counsel, but what they filed was a whole new action for.
Yeah, that I have a problem with, but I just have a problem with the $175 that so,
Well, you're right.
because I don't understand why this case was filed. Because you're filing on something that theoretically, at the same time you're arguing me, is part of another case, which this case shouldn't have been filed, which means that one could think that this is a frivolous action and award cost and sanctions for filing of this case. I don't know that you want me to go there. I will.
I believe it does. Court cost is part of past due rent if they're not paid.
When awarded. You have a, okay, we can go around and round about this. So what do you want me to do with this case? The one here today. Because if you're gonna amend on the other one, I can't have both of them pending.
You only have one attorney right now, Your Honor.
I can bring another one, Miss Lacy, if you want me to, because I can rule on it today.
I haven't filed anything, Your Honor.
No, I mean, I can rule on it right now. I still have jurisdiction over that case. So I think you better be very careful how you're treading and what you're saying.
I'm just saying.
What do you want me to do with this case today? Do you want it dismissed or do you want me to adjourn this case out?
I'll have you adjourn it, Your Honor, so I can.
Well, I'd like this matter closed, dismissed today, Your Honor. And I believe the 175 is not a valid order and this petition, this action should not have been filed. I'd ask to be dismissed today and not adjourned. I would ask for attorney fees.
I'll adjourn this matter to February 27th, 2026 at 12 noon. The issue of defendant's attorney fees, the court will take under advisement.
And I'm sorry, what time was that term?
That's at 12 noon. Thank you.
Just another pretrial or?
I have no idea. But yeah, it's just another hearing date.
Oh.
We'll do it. Deal with it. Thank you. Beal Properties versus Tayana Young Joyner. And Takia Young and Toya Joyner. None of them are checked in. Do you wish to take a default? Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, go ahead.
Thank you, Your Honor. This is a one-payment rent case where we're requesting a default judgment for possession only. With the outstanding rent retained $1,447.23, court cost $175. Total outstanding balance is $1,622.23. We are requesting a pay or vacate date of February 23rd, 2026. I do attest to the best of my knowledge of the people. Age of 18, have been adults, not fully active duty, with
Judgment to the plaintiff, that's by default for possession. Redemption amount in the amount requested with the writ issued in 10 days. Court calls the case Beal Properties versus Montana Patrick.
But the tone shifted fast in the next case. A landlord tried to collect $175 in prior court costs through a new lawsuit. The judge pushed back hard. Why are we here? Warning about possible sanctions for a frivolous filing. He adjourned the case and took attorney fees under advisement.
In relation to Beal Property.
Your name, sir?
Matata Patrick.
All right. What is plaintiff's claim in this case?
Thank you, Your Honor. At this time, there is past due rent to retain of $4,853.36. Court cost of $175. Total outstanding balance is $5,028.36. I did have an opportunity to speak to Mr. Patrick, and he is also here with someone from the housing community that is helping him. They do have a confirmation from SOS to help him with a significant amount of this balance, and then they're going to take care of the rest. So we're just asking for another 2-week adjournment so that he can tie up those loose ends.
Is that correct, sir?
Yes.
Yes. February 27, 2026, 12 noon. All right. Thank you. You're all set.
Thank you.
Beal Properties versus Cosine Welch.
See for Beal Properties.